Let's go over one of the motions in limine that was filed in the Aaron Spencer case. This one's called Motion in Limine to exclude evidence of Spencer's conduct from July of 2024. Decedent Michael Fossler was charged with multiple felony counts for sexually assaulting Spencer's daughter. Fossler was arrested on July 11, 2024 after Spencer's daughter made initial disclosures on July 8th of 2024. The state's discovery file contains a report from Lonoke County Sheriff's Office Deputy John Ingram about a meeting with Lena Higginbotham and her daughter Paula McFarland on July 8th of 2024. The report alleges Higginbotham and McFarland told Ingram that Aaron Spencer had requested details about their mutual friend Michael Fossler, and that when Higginbotham and McFarland asked Spencer why he wanted Fossler's information, Spencer told them that Fossler had raped his teenage daughter and allegedly begged for them not to call the police. Ingram's report then notes he spoke with Spencer at his residence, and that he was extremely angry at first and refused to talk about the possible rape, but then calmed down and cooperated fully with law enforcement's investigation into Fossler. This court must exclude any reference to or evidence about Spencer's conduct in July of 2024 pursuant to Arkansas's Rule of Evidence 401, 402, 403, and 404B. The evidence is not relevant and is inadmissible pursuant to Arkansas's Rule of Evidence 401 and 402. Spencer's conduct in July of 2024 has no bearing on whether his use of force against Fossler more than 3 months later in response to Fossler kidnapping, sexually abusing, and possibly eliminating his daughter as a witness in his own criminal case was justified. The evidence must be excluded as irrelevant accordingly. Prior bad acts evidence must be independently relevant to the main issue, relevant in the sense of tending to prove some material point rather than merely to prove that the defendant is a criminal. The evidence at issue has no independent relevance to the charged act. Whether Spencer asked associates of Fossler for information about Fossler more than 3 months prior to the charged acts in this case has no relevance to the charged acts. Whether Spencer was angry and or initially refused to cooperate with law enforcement into the investigation of Fossler, an investigation he then cooperated with fully, has no relevance to the charged acts either. Such evidence may be relevant if Spencer was alleged to have stalked Fossler and killed him at his home or out in public. However, that is not what happened here. Rather, Spencer awoke in the middle of the night to find his teenage daughter missing and happened upon Fossler's truck as it turned down Spencer Street. While out searching for his daughter in his truck, Spencer was not looking for Fossler. Rather, he was looking for his daughter. He just happened to find Fossler with his 14-year-old daughter mere months after Fossler's arrest for sexually abusing her. What followed was a lawful use of force in defense of his daughter and himself. The issue here is whether Spencer validly used force in defense of his daughter and himself, not whether he had any specific intent to kill Fossler prior to the incident at issue. The evidence is inadmissible accordingly. Instead, this evidence is the worst kind of evidence meant to encourage the jury to find Spencer guilty in accordance with his character for having sought out Fossler's information to handle the issue himself, despite no actual proof of such, to encourage a vigilante narrative that is simply lied by the actual facts of the charged offense, rather than evidence associated with the charged offense. Any marginal relevance the evidence may have, which Spencer does not concede, is outweighed by the dangers of confusing the issue and unfair, and must be excluded pursuant to Rule 403 accordingly. The trial would become about whether Spencer had previously sought to handle Fossler himself in July of 2024, rather than whether he was justified in killing Fossler in October of 2024. Following Fossler's abduction of his daughter, the state will be able to argue some of the pre-existing intent despite no alleged connection between Spencer's July of 2024 comment and use of force against Fossler in October of 2024. This court must exclude the evidence pursuant to Rule 403 accordingly. The evidence does not fit into any exception listed in Rule 404B. In fact, it is precisely the type of evidence that Rule 404B exists to keep out. Further, Admission of this evidence would violate Spencer's due process rights. The court must exclude this evidence at issue accordingly, wherefore the defendant respectfully requests that the court enter an order precluding the state from offering any evidence about his July of 2024 conduct during the trial in this matter.